able to do justice because we have spent substantial time in preparing the material and delivering it to you in earlier batches as well. So Dr. Anandya would be taking this class, and the remaining classes will be as per the timetable given to all of you. Okay, I think without losing much time, as we have discussed the other day, and I'm also very happy that a large number of students have participated in the deliberations and raised a lot of questions. And that is the way the class should be. You people should ask questions at the end of the class. That is very, very important, so that you will also learn, and it will also help others to learn about the subject. Yes, Dr. Anandya, as you all know, we have about 4 faculty members from our Center for IPR. I am one of the faculty members, Dr. Anandya, Mr. Raviteja, and Mr. Satyanarayana. So we 4 of the faculty members of this center will be dealing different aspects of intellectual property rights as given in the timetable. So you can we are also in the same South Campus where you are all here opposite to Vice Chancellor's office, and you are always welcome to the office and get clarifications for your doubts. We are always available here. Okay. Dr. Anindya is also very experienced a researcher and a teacher. She has been teaching this course almost for the last 1.5 years here. Earlier to this, she was also in IIT Kharagpur. She was also part of the Swayam NPTEL programs where number of faculty members, students who were interested to learn here. She was managing some of the programs by IIT Kharagpur in the area of IPR. Yeah, Dr. Anandya, you please take over and you can carry forward.
Okay, so IPR are all territorial rights. So this is another important thing to remember, is that in the country where you get the IP rights granted, your right is valid in that country only. That is the meaning of the term territorial rights. So if you file a patent in India and if you get the grant in India, your patent, your legal right is valid only in India. It's not valid in Pakistan, Afghanistan, Bangladesh. You think that nearby areas, it's not like that. It will be valid only in that countries. So it is a territorial right. If you wanna get your right over there in the US, you file in the US. Okay, so this is a territorial right, and IPR, like any other property, intellectual property rights, right? This is a property, so it can be assigned. This right, you can assign it, you can gift it, you can sell it, you can license it like any other property. So the same kind of property rights that you get when you have something like any property, like maybe if you have a mobile, that is your property, so you can gift it, you can sell it, you can just do whatever you want, like that. This is another property. This is called intangible property. I hope you guys have understood that. Any, if you have not, I'll say it again. Anything intangible that you cannot touch is called intangible. All these IP rights are intangible. That is something that originates in the human brain, right? But if you have a mobile, if you have a house, if you have a car, those things you can touch. So those things are called tangible right, tangible property. Uh, yeah, it was territorial right, and as I said that if you want to file it, if you want to get the right over any other country, you have to go and file in any other country. There are ways to file in several countries, but please remember, there is nothing called international IP rights. There is nothing called international IP. You have to go to the country, you have to file in that country has to grant it, otherwise you will not get that right in that country. This is called WIPO, WIPO. So you can see below it is written, WIPO is a specialized agency of United Nations. So World Intellectual. So this is a global forum for intellectual property services, policy, information and cooperation. It is a self-funding agency of the United Nations with 193 member states. So for all these kind of treaties, as I said, that countries need to agree and sign that treaty, then they become the member of that treaty. So there are 193 member states, we call those countries member states. So there are currently 193 member states for WIPO. This is the building of WIPO. There are two main objectives of WIPO. First of all, to promote the protection of intellectual property worldwide. That just means that in every country you have to promote the protection. That doesn't mean that intellectual property you have to protect one intellectual property worldwide. It doesn't mean like that. Next, to ensure administrative cooperation among the intellectual property unions established by the treaties that WIPO administers. There will be several kinds of treaties. We call that treaty. If you are from non-science department, you will be able to understand what is treaty. This headquarter is in Geneva, Switzerland, but there are liaison offices. For example, in Brazil, Rio de Janeiro, and then in Tokyo, then in Singapore, and then in New York. There are some liaison offices, but the headquarter is in Switzerland. These are the services provided by WIPO. If you go to the WIPO website, did I give you the WIPO link over there? Yeah. So the WIPO link is there on your screen on the slide, and here you can see what are the services that is provided by WIPO. They are clearly saying there are many IP services, patents that will be By the way, I will take the patent class again, so you don't have to worry about it. You just see the patents and trademarks and then designs and geographical indication, dispute resolution, that will not be covered under our IPR classes, and domain names that may be covered under trademark. So these are the things that WIPO will administer. There is something called WIPO Academy. If any one of you is interested in learning some more IP thing, then you can just go to that link on your screen and you will be able to register for some new courses also. Free courses are there also, distance learning course 101, like that, so you can learn some more knowledge from there also. This is the academy and is the center for excellence for intellectual property education, training and skills building for WIPO member states. In particular, developing countries, least developed countries and countries in transition. You understand what is transition, right? From least developed to developing, like that. This academy works to help build human capacity in IP, which is essential to innovation, which is essential for innovation and creativity. So WIPO Academy, if anybody is interested to learn, you can just go there and log in there, create your own account and you learn something. I hope this thing is covered, but still I am covering this thing. There are two kinds of intellectual property. Please remember, two kinds of intellectual properties. One is called industrial property. Industrial property under intellectual property. Under industrial property, all these things will come, that is patents, trademarks, industrial design, geographical indication, topography of integrated circuit, plan variety protection, trade secrets, all these things will come under industrial property. What will not come under industrial property is copyright. So that is another kind of intellectual property. So there are two kinds of intellectual property. Please remember, one is copyright, another is everything together is called industrial property. So copyright will be given for artistic works, literary works. It can include computer software and databases also. And there is something called related rights. You will have separate class for that. Performers, phonogram producers, broadcasters, they will have all those related rights. Okay, here I have gathered some information regarding how trademark was also there in ancient times. If we go back to 5000 BCE, there used to be some cave drawing. People used to live in cave at that time, but they used to draw something on the cave wall that shows that they are from this group, from this tribe, they belong to this tribe. So basically that is the way of their saying that we belong to this group. Trademark today is the same concept. If you see one Pepsi trademark and if you see some product leveling the word Pepsi, you understand that this is from this group, Pepsi group. So the same thing was there in 5000 BC, in 3500 BC, Mesopotamia, people started living life in a civilized way, right? That was 3500 BCE. In Mesopotamia, there was some cylindrical, on your right you can see there are some cylindrical seal that the kings, they used to have their symbol like some seal. So that was there in 3500 BC. That is the same thing like today's trademark. Then 3000 BCE also there was some bricks and pottery, roof tiles, something like that from the Egyptian dynasty. From the Egyptian dynasty, they used to have separate bricks and pottery, something like that. That shows that this belongs to this king, this only to this king. So these are all kinds of trademarks that used to be there in the world. Then 1266, this is BC, then I'm jumping over to 1266. Earliest English law on trademarks is that the baker's marking law. Some bakers stamp a mark on their bread. 1266, you cannot expect a lot many technological invention. At that time, they used to make some mark on the bread and that is their trademark. 1857, the trademark law was enacted in France. 1862, the trademark law was enacted in the UK. Then 1876, Bass Brewery registered their first trademark in the UK. All these are for your information, your GK. I'm definitely not gonna ask who filed first trademark in which year. I'm not gonna ask. 1887, Coca-Cola first used a trademark for a tonic beverage. 1895, Quaker registered their trademark for oats. 1977, Coca-Cola's bottle was registered as a three-dimensional mark. This is an important thing, but I will take the class of trademark again, so you will be able to understand it, that the Coca-Cola whole 3D bottle, that shape is a trademark. It's not about just a name or a logo that we generally think of trademark, just the way I said about Pepsi. So Coca-Cola is another logo, so it's another trademark, but the Coca-Cola whole bottle, the 3D shape, is a trademark. We will talk about it later also. So that was about trademark. Now it's about patent. How the patent system was in the olden days. The practice was to grant privileges as early as in 12th century in Venice. So as you know that everything used to happen in Italy long ago. Nowadays everything happens in the US. So at that time Italy used to be quite the Renaissance over there. So in 12th century Italy, they used to have some period of monopoly right for 10 years that used to be given to the inventors for silk weaving process for their clothing, for their textile system. In 1297, a decree was passed in Venice that if a physician, so it's about the medical field, if a physician made a medicine based on his own secret, it had to be kept within the guild and all guild members had to swear not to pry on it. So it's like some confidentiality agreement that came into Italy in 1297. So you can understand it's long ago. The Venetian law on patents of 1474 came. It was about protecting the new and useful devices. Once introduced in the market, they were qualified for patents. The patent was also for a limited time. Then from 1561 to 1590, Elizabeth, that's in the UK, granted about 50 patents in manufacture and sale of commodities like soap, alum, leather, salt, glass, knives, sailcloth, sulfur, starch, iron, paper. You can understand these things are very important in trade at that point of time, 1561, not technological invention. So those things were very important to protect at that time. This is the history of patent system, just whatever I told you, just like that. So 1474 Venetian patent ordinance came, then 1602 first patent case. Case means a legal case in the court. Darcy versus Thomas Allen, it came. Then 1623 Statute of Monopolies in the UK. 1790 first US patent law. 1791 first French patent law. 1800 to 1882 patent laws in most European countries. It came into the picture in most European countries by 1882. And here you can see 1856 first Indian patent system, 1883 Paris Convention, 1970 Indian Patent Act. These might be important. When Indian Patent Act came into the picture, I will take the patent class again. 1970, 1970. This might be important. This is important. Then 1970 Patent Cooperation Treaty for 123 countries. 1994 Uruguay round, that might not be important. Evolution of copyright system. Copyright came into being after the printing machine was invented during the Renaissance time. Initially the right was meant to protect the publisher only rather than the authors, but nowadays the authors are also very important. Economics of publishing was the key point, as the aim was to publish books available to public domain, mainly Bible at that point of time during Renaissance, right? Rights of authorship were not important, but now rights of authorship are also very important. So copyright also cover the author's rights now. First copyright appeared in Italy. As you can understand, everything appears in Italy when printing was introduced in Rome and Venice. Evolution of design system. I hope you guys understand all these are different kinds of IP rights. First trademark I said, then patent, then copyright, then design. All these are different kinds of IP rights. Designers of new type of design for weaving were given exclusive rights in 1580 for a period of 2 years in Italy. 1580. First design protection was created in France through an ordinance in 1711. Bylaws for protecting designs were enacted in England in 1787 for woven product design. In Japan, it came into existence in 1888 for textile design. You can see all these things were for textile design. Then plant breeders right, that is another IP right. There are two concepts in plant breeders right. One is plant patent. That terminologies occur in the US only. In India, we have protection of new plant varieties and farmers right. We don't call it plant patent. We call the word patent only for invention In the US, they call it plant patent if you are applying anything related to plant, and if you are applying for design, they also call it design patent. So they have three kinds of patent: plant patent, design patent, and the regular patent that we give and everyone else give, they call it utility patent. The first Patent Act came in USA in 1930. French started discussing protection of new varieties of plant in 1950s. UPOP came into existence in 1961. UPOP is about plant variety protection. I will take the class again. You will learn then. This is another IP rights geographical indication. Origin is in the appellation of origin for wine dependent upon quality and nature of grapes. The earliest reference was in Bible: wine of Samaria, wine of Carmel, wine of Jezreel, wine of Helbon. All these references were there in Bible. So the way they say, the way they include the location name in the product name is basically the geographical indication. How you indicate from where from which geographical origin the product originated, like wine of Samara, just like that. First vineyard classification system was introduced in Hungary in 1730. It is accepted in many countries that are members of Paris Convention. Evolution of IP system in India. So whatever I just told you about all the someone is not able to see my screen. I guess other people are able to see. So this is only about the IP system evolution in India. The Act 6 of 1856 on protection of invention based on the British patent law came in. British patent law of 1852 came here because at that time British people were here. We didn't have our own laws. So the British law, it came and it became here a law 1856. Then Indian Patents and Design Act. So patent and design they were combined together, and the act was called Patents and Designs Act. That was in 1911. That is also before we got independence in 1947. So this is in 1911. Act 2 of 1911. It brought the patent administration under the management of Controller of Patents for the first time. So this act brought the patent administration under Controller of Patents. That was the first time. After independence, so after 1947, it was felt that the Indian Patents and Design Act 1911 was not sufficient. So they need to change, they need to amend the act, they need to do something because we are a different nation now. We need to do something different. Our own law should be there. So that law, the present law that we teach, that we read, came in 1970. As I said, this is important. 1970, the patent law came into picture in India. The act was amended for science students who have not heard the word amendment. When the act is modified based on the recommendation, based on the requirements, that is called amendment. So the Patent Act was amended 3 times in India: 1999, 2002 and 2005. After 2005, the act has not been amended. But there is something called patent rule that is continuously being amended. When I will take the patent classes, you will be able to understand it. So Patent Act is from 1970. There are 3 amendments: 1999, 2002, 2005. That is the end of Act amendment. These are the IP acts in India. Trademarks, there is Trademarks Act 1999. Patents, there are Patent Acts 1970. Copyrights Act 1957. So that is the oldest IP Act in India. Copyright 1957. Then Industrial Design 2000. Design Act 2000. Geographical Indication, that is 1999. Layout Design of Integrated Circuit, that is basically all the semiconductor IC layout design, that is in 2000 again. So the design and this design, don't be confused between these two designs. These are completely different. There will be different classes for that. All these, both the Design Act came in 2000. Then Plant Variety, the Plant Variety Protection and Farmers' Right Act, that is in 2001. So that is the most new act in India. This is about all the IP acts in India, and this is all about today's class. So there are some important acts in India that you might need to know. Just need to remember. this is relevant for IP acts in India, but these are not IP acts in India. There is Information Technology Act 2000, IT Act, that is, then IPR Enforcement Rules 2007, then Competition Act, that is relevant for patent 2002, and then Biological Diversity Act, again relevant for patent 2002. So these are the important acts in India, but these are the IP acts of India. So when I share the PPT with you, you see the slides number 29, these are all the IP acts in India. So that's all for me, from me for today's class. Thank you so much for having the patience. And then if there is any question.
Students, you may unmute yourself and ask questions.
The audio voice system should be enhanced. Very feeble voice is coming.
Why should be? I didn't get the question. Why system should be?
Voice is quite audible, sir.
Okay, guys. So is there any question? So I can answer it. Otherwise, I'll just share the attendance link is there, I guess. It has been shared. So from next class, you will get the whole IP Act. Today's class was just to give you the overall idea about how the IP system came into the picture. This is a general, very general idea.
19, 22, 24 all are present, madam.
If so many people say something simultaneously, I'm not able to hear it.
People who are not interested in the class, you may please leave. Those who have any questions, you may please unmute yourself and ask the questions.
Also present, madam.
Hello.
Yeah, hello, Jairaj.
Sir, could you please share the PPT, sir? Because I am from the starting of the class, I didn't see that screen sharing. So could you please share the PPT?
PPTs will be shared later with your CRs.
Okay, sir. Thank you.
If anybody has any questions, you may please ask the madam.
For Ramu, if the patent is not protected in India, basically you have to file the patent in India, not copyright. If the patent is already protected in the US, so you can get it in the India also. I just hope. You have to file it in India. That's all.
మరి డీటెయిల్స్ ఎక్కడ ఉంటాయి ఎక్కడన్నా ఉంటాయి
For Prashad, I will try to slow down in my next class. Next class is on patent, so I will hope that I will slow down. Thanks for reminding me. I get that.
Good evening, ma'am.
Yes, please. Good evening.
Ma'am, can I know about related rights? I think you didn't explain
Yeah.
about related rights.
No, because I'm not explaining anything over here because there is a separate class for that, because when you learn copyright, I think there are 2 classes on copyright, so you'll be able to understand it in a great detail about related right. So I'm not going into any detail of any IP right in today's class. This is just about giving the history, because today's class the topic is evolution, how it came into the picture. I'm just telling you that only.
Okay, ma'am. Thank you.
You're welcome.
Ma'am?
Yeah, please.
Ma'am, what about when MNCs are using, because MNCs have a lot of companies in other countries, so if there are 2 patents which are patented in 2 different countries, and when MNC is using, so will it be a problem when if they are using a patent in the same country which has also already has a patent registered, but it may be it may be similar but in a different way. Like pharmaceuticals basically will have some problems because the combinations will be similar, but the way they patent it is different.
So when for these MNCs, they are very careful about their business, right? So when they file it in a large number of countries. It's not like later on they came to know, oh my God, we lost it. It's not their case. So they generally file it in several countries and they protect their invention in several countries. For example, pharmaceutical or anybody like that. This thing that they came to know about it later and they understood that they missed it. That will happen for small countries, small companies only. It generally doesn't happen for MNCs. There are ways to file your patent in several countries within by just one step, that is called PCT. I will tell about it in detail in my next class, patent. So you will know that is the route that the MNCs take. They file in several countries. Is that Nikhil? No, Nakili. Sorry, Anand.
Thank you, ma'am.
Nobody needs to write your name or roll number here. I think the attendance link will be provided, so you can just put that over there.
Ma'am.
Yes.
Ma'am, please try to share the
PPT.
material, ma'am, because it's
yeah,
like
sure. I will share. I can understand there was a lot many things.
Okay.
But as I said, you don't need to remember all the years. You need to remember just the Patent Act years, the IP Act's years in India. Slide number 29. But I will share it.
Thank you.
Somebody asking foreign countries applying patent in India. Countries do not apply for patent. Individual or companies, they apply for patent. For example, our Andhra University, they can apply for a patent. Or you as an individual, in your individual capacity outside the university, if you are not associated with your university, you can file the patent. So, countries do not apply for patent. I hope that is clear. And anybody can file a patent in India if they want the protection in India. So if you mean that any foreign person can apply a patent in India, yes, you can. If you wanna have the protection in India, so you can file it.
Ma'am, can a patent claim can be challenged?
Is that what is the question? Patent can be challenged. Yes.
A patent claim can be challenged?
Yes, definitely it can be challenged. So that is a very good question. Are you from law background?
No, I am from a history department.
Yes, definitely patent claims can be challenged in the court or at patent office also. So there are few process of opposition. I can tell you now also, but I have different classes on that. So when after the patent is filed, it will be published. When it is published and when it is available on the patent office website, anybody can file the opposition on anything. There are several grounds. There are 11 grounds you can file the opposition. So you can challenge it. And then after the grant of patent also, within 1 year, we call it post grant opposition. Again, you can challenge it. Even if it is after 1 year, you have the process of revocation. Again, you can challenge it. So yes, it can definitely be challenged. As you can understand, these are legal rights. So the court will be involved.
Thank you.
You're welcome.
Ma'am, so if the patent is challenged, then how the decision will be made, ma'am? Who's the patent, who's it belong to?
Yeah, if it is in the court, you know, in court, everything like court cases, everything happens like that. So, for example, I have a patent that I was not supposed to have. I took it from you. So basically, I filed it wrongfully. That is your patent. So you filed opposition. You filed the opposition that my patent, my claims are not valid. So we both have to go to the court. Here you are the plaintiff. You have filed the patent. Oh my God! You have filed the opposition. You are the plaintiff and I am the defendant. So we will go and we will make our cases. Now it is up to the judge. The judge will decide. So my patent, basically, if I have stolen the idea from you and everything is visible, so the judge will decide the patent is not valid. So it will be just invalidated, just gone.
Yes, madam.
Is that clear?
Ma'am, but if both the parties are showing the similarities equally, then it will be a problem for the judge to decide.
See, court and judge, that's a really difficult case. I don't know how the judge decides, but generally in every case in the world, they decide based upon the evidences. So how much evidences you are providing? In this case, if it is very evident that I have just plainly stolen the patent from you, you have all your evidences, you have your lab notebook and everything, you have just shown it to the judge, so definitely my patent will be invalidated. But there can be complicated cases, so the judge has to decide.
Yes, ma'am. Thank you, ma'am.
You're welcome. Anything else? Otherwise we can just wind it up.
Good evening, madam.
Good evening.
Ma'am, I'm Samyukta and I'm from Fine Arts Department. I'm currently pursuing my master's in painting.
Okay, that's good. So yours will be relevant to copyright. Anyway, say.
Yes, ma'am. I'm completely new to this subject.
Of course.
So, and I just wanted to ask, like, how are these intellectual properties relevant? Like, how will they be helpful to my course?
So for you, copyright is relevant, definitely very relevant. Copyright is a different system, For example, for patent, you have to file the patent application, but for copyright, your right is, when you create it, your right is already created. But if there is an infringement, if you have created something and I have, see again I am taking my example, so I am just copying your work and I am putting it on internet, or I am selling it and I am gaining some commercial benefit out of your work, so you can file the infringement case on me, but in that case your copyright has to be registered.
Okay, ma'am.
Do you understand? So you get your right by default, but if you wanna go after somebody that who is stealing your work and who is getting commercial benefit out of it, you need your register to be, you need your work to be registered. So that is something important for all the classes. There are several different departments here, but IP will be relevant to all the departments. For example, you are not from any science, you are from fine arts, but copyright is so much for you. So
Okay, ma'am.
yeah. Thank you.
Thank you, madam.
You're
Thank
welcome.
you.
How can a patent can be extended for a lifetime? So, like
No,
we can.
No,
I read somewhere, but that US has a limit that after 20 years we can extend the longevity of the patent
no. That is
as
a
we
different
wish.
case. That is a different, no, and not as you wish. That is a different case. There is an extendable amount available in the US only if in the case the patent office has made some delays. When the delay is from the patent office, there was some undue delay made by the patent office, then you can adjust that timeline and add it over to your timeline. That is only available in the US, but it's not available forever. You cannot just, lifelong, you cannot just do like that, because patent is for technological invention. All the technologies, they become obsolete, so basically it's a loss for you also. If you have to keep on filing the renewal fee, you don't need it anymore. So in general 20 years is enough. Generally so many companies or so many good patents, they don't even renew it for after 10 years because it becomes obsolete. They develop something new and they get patent over there. So there is no point of getting patent for lifelong. But for trademark it's very different, because that brand and logo will be there lifelong, so you need to keep on renewing it. That's why it is for lifelong. Is that clear? I hope that is clear. Anything else? So if nothing else is there, I guess I can, for Joseph, I will take few classes and there are my colleagues, they will take few classes. I will take patent and trademarks and something else. The class schedule is already shared with all of you, so you can see over there. My name is Anindya Roy Chaudhary. You can see in your class schedule ARC. There is basically no purpose of creating because you already created, but there is a purpose in protecting it. If anybody is gaining undue advantage based on your creation, then you can go after that guy, you can file some infringement, you can protect your own thing, whatever you have created. Basically people are all very creative, right? So intellectual property comes out of the intellect of human being. So that's why the need of protection arises. First you create the IP, then you understand through this class or some other thing that you have created one IP. That is very important to understand. So then you go for protecting it. And then if you are granted that right, then you can enforce that right also. So I'm not sure if my voice is low to everybody or just some people.
Your voice is absolutely fine, ma'am. Maybe the others have some problem in their network. You are 100% full strength, no problem at all.
Okay, thank you so much. So Swarna.
Hello, ma'am.
Yes, please.
Ma'am, I have a small question.
Yeah, sure.
So, let's say if I want to check on a thing, if it is patented or not, or if it is
There are several
patented in what
databases,
country?
right? There are several
Okay.
databases. So I will discuss about that also. There are several free databases, like just like Google, there is Google Patent. So right now on your screen, you can just type Google Patent and open the page. Like Google Scholar, I don't know whether you guys use or not. Google Patent is there. So there you put any keywords and you will file the patent. So there you can see in which countries the patent has enforced, in which countries it has expired, like that. That is just an example of free patent databases. There are several patent databases from Patent Office also. We have our patent database, Indian Patent website, Indian Patent Office website, like that, USPTO, US, United States, and then Japan, and then all these things, European Patent Office. And there are some paid databases also where you get some extra information. They will give you some graphs also, some more extra things you can do. So there are several ways to find that.
Thank you, ma'am.
You're welcome.
Oh, you told what is Google Scholar actually?
Google Scholar, if you are searching for any paper, any publication, I don't know you guys are working on any publication or not, or if you are working on any research topic, any project topic, you need some prior art, you need to learn some literature search, right? So you go to Google search, sorry, you go to Google Scholar, just in the Google you type Google Scholar, so Google Scholar opens and you put your keywords, you will see all the publication based on those keywords. So Google Scholar is for researchers like us. You can create your own profile also. You can see your H index also, if you guys are aware about that. So
Yeah.
it's all about for research.
Okay, thank you.
You're welcome. You cannot patent a logo, Joseph. That will be a trademark. Patent is only for invention. So I will take the classes and I will clarify these confusions. Any other question? Divya, is it for earning purpose? Not really. If you commercialize your IP, then definitely you can earn a lot. But basically you protect it from any other person using your creative thing. That is the main thing. That is the main purpose of protecting your creation. for Divya.
Ma'am,
Yes, please. Yes, please. I don't understand the question. Atish. Yeah, please. The question is the chat box is not clear about your college details. I'm not sure what does that mean. But yeah. Anybody wanted to ask anything? Yes, please.
When you say foreign country filed an IP in India,
So you didn't
then
hear. I said no country files a patent. An individual will file a patent. I can file a patent. You can file a patent. Otherwise, the university can file a patent. By the way, please remember, when you are associated with the university will file the patent. The university will bear the all filing cost. The country does not file a patent. Individual companies, universities, startup companies, any MSME, that will file the patent. But any foreign people can file. You can file in any countries. Any foreigner can file in India. So there's no bar. But countries do not file a patent. This is about individual right or any company's right, university right, like that, any entity.
That
Yeah.
is called a
And if
legal
someone
entity. Any legal entity can file
Yes. Thank you for explaining. Any legal entity or any individual.
and if some party filed a IP in India, then if any dispute arises between the party, then it will be dealt with Indian law or according to international law.
India. If you have filed a patent in India, if it is granted in India, so everything happens in India only. Why international picture will come? Wherever it happens, in that land, law will protect it. That land law will decide. Sham Kumar, yeah, definitely. You can sell your patent. As I said, this is just like a property, so you can definitely sell it. It's up to you. You can sell it, you can license it out, and you can get money out of it. And yes, that can be to any person or any organization. It depends upon you what you wanna do with your property. You are right. So I hope that is all. I can answer all your patent question in my next class. Trademark question in next trademark class.
So anything we need to prepare and come for next class? Do you need any? Do you want to give any inputs to us so that we come prepared for the class, ma'am?
I don't expect you guys to become a really expert in patent or in
Okay.
any IP. But if you just know what is patent, you cannot patent a logo. These are the basic thing, because now it will be definitely good if you guys have already covered what has already been taught. So what are the total number of IPs and what are those IPs are given for? If you are clear with that, I think that will be good enough.
Right, ma'am. Thank you, ma'am. And do we have any recording of these classes so that in case you upload to YouTube or give us any link?
I think there is.
Is it provided here in the chat box, that link, or do you mail it to us, ma'am, to all the people?
About that link, Ravi? Maybe I'm not sure because I'm in the class, so I'm not sure about the link.
No problem, ma'am. But basically, from yesterday onward, whatever the previous class and today's, if we can, at our convenient time, we can listen again. Of course.
I can understand.
Yes,
I can understand. So I just heard the YouTube link is active. It is
Oh.
active, the link is active. So, and it is recorded also, right? So, if you go there, you can listen to the class again.
Oh, right, ma'am. Thank you very much.
You're welcome. So, I think anything is patented outside India, should you get patent for the same in India? So, there is a thing. If you file a patent in the US, you have 12 months of time to file the same in India. So your priority will be drawn. These are some terminologies like priority or something like that. I will explain it in the later class. So you have still time of 12 months to file the same patent in India. In that case, India can also grant the patent. But if you wait more than that, then it is not possible for sham. I will discuss all these things. Okay. So yeah.
Ma'am, somebody has patent in USA and somebody from India has copied that patent and getting money.
In
And
where
how does the
getting money?
judiciary
Where he is getting
Hmm?
money? In India?
in India?
Nobody can do anything.
Yeah.
That is that guy's fault that that guy didn't file patent in India.
Mhm. Okay, thank you, ma'am.
You're welcome. Okay. So I hope that's all. So I will close the session here. Okay. Thank you all for joining today's class. The next one will be there in your timetable. I will take the pattern part. Okay then. Bye for today. Thank you. Any meeting for all, right? This one.